to the fact that this was a protection for states, for their integrity, and for their ability to innovate in response to citizens' needs. So, Commerce Clause limits don't apply when the state is acting as a market participant. But be careful. Sometimes the state might look like a buyer or seller and try to claim that it's freed of Commerce Clause limitations, but if it places conditions on the purchase or sale that are really an attempt to regulate beyond the immediate transaction, it can go through metamorphosis, if you will, and instead of being a market participant, it can become, yet again, a regulator. An example of that would be a case out of Alaska. Alaska had timber that it grew, and we're not talking about just a natural resource here, because the rule about market participant doesn't apply to protect resources and allow states to hoard them for its own in-state people. This timber that we're talking about was really the business of timber. Alaska culled the timber, it took care of the timber, it was basically in the timber industry, you might say. And when it sold its timber, it sold it to purchasers, but required that those purchasers, as a condition of the purchase, promised that they would process the timber first in the state itself. And in that case, a plurality of the court said, no, here, this is a form of regulation. This is not the market participant doctrine applicable. Alaska's trying to regulate what's going on downstream beyond the original purchase and sale, and this looks more like regulation to us. So therefore, this requirement that you perform certain amounts of your business in the state, because it's discriminatory, was struck down under the Negative Commerce Clause. Now, a second way to avoid the discipline of the Negative Commerce Clause is under a doctrine known as congressional authorization or congressional permission. And it works like this. Even though, under the Negative Commerce Clause, a state may not discriminate or excessively burden interstate commerce, a state is wholly free, completely free to do those things if Congress allows it to do so. If, in other words, Congress gives it permission. Because just as Congress can speak and preempt state action, it can speak and permit state action where it would otherwise be prohibited. Just as one example, when we looked at the case of Philadelphia versus New Jersey, and we said that the court struck down New Jersey's ban on out-of-state garbage, the very next day, Congress could have passed a statute and said, New Jersey, or any other state, you can adopt total bans on the importation of out-of-state garbage. And anytime you want to get around the Negative Commerce Clause, if you have facts to argue, if there's a basis to argue that Congress permitted to states to take a discriminatory action or an excessively burdensome action, that's a good way to go. However, be careful here. It has to be very clear that Congress was actually authorizing the behavior that's being complained of. The court's not very eager to take general congressional statutes and find in them permission to states to discriminate or unreasonably burden interstate commerce. So, to review, in terms of states, states are prohibited from doing certain things under the Constitution because they're expressly prohibited from doing those things, like entering into treaties, or they're expressly prohibited from doing them unless they get congressional approval, like taxing imports or exports. And other than those limitations, states are also limited by the doctrine of the supremacy of federal law. If there is a federal law, and I mean any federal law, it could be the most modest of federal laws, it doesn't have to be the Constitution or a treaty or even a statute, it can be a regulation. If you have federal law and it's in conflict with state law, federal law prevails. And here again, it doesn't matter what the nature of the state law is either. It could be the loftiest state provision embodied in the state constitution. That doesn't matter. Federal law prevails over conflicting state law. And finally, if you have a situation where state law or local law, even in the absence of congressional statutes, where it discriminates or unreasonably burdens interstate commerce, that's also a basis to strike down state law. Okay, now we will make a big shift. We are going to shift from powers, who gets to do what in our scheme, to individual liberties. And we start first with a gateway or entryway doctrine, namely the doctrine of state action. The reason why we start with state action is that except for the 13th Amendment, which abolishes slavery no matter who's doing it, all other constitutional guarantees are applicable only as against government invasion. They do not apply to individuals or businesses or non-governmental entities. For example, say you think your First Amendment rights have been violated, they can only be violated by governments. If you go over to somebody's house and they tell you to shut up and stop talking, and you believe you're prevented from speaking, you don't have any First Amendment rights against that person. They are not a government. Or let's say someone searches and seizes your wallet. You don't have a Fourth Amendment claim against that person. You might have other kinds of claims, statutory or common law claims, but you don't have any constitutional claims. So, in order to raise constitutional guarantees, except for the 13th Amendment, you have to be claiming that the state or the government is causing the harm to you. Now, in the usual case, it'll be obvious that the government is acting. For example, you'll have a statute or a law that's passed by the government, or an agent of the state is obviously taking action against you, like a police officer. And by the way, this includes unlawful acts by government officials too, so long as they are clothed with state authority. If they are acting unlawfully, but they're acting in uniform, as for example, an official beating someone after stopping them for a traffic violation, that still counts as state action. The really hard question comes, though, where we have the state acting together with a non-governmental entity. Under some circumstances, and we have to see which, that can count as governmental action. I suppose we could begin by asking why we have a state action doctrine at all. Well, first, we have to have some line between governmental and private conduct because the Constitution seems to anticipate it. The First Amendment, for example, says that Congress shall make no law. Or the 14th Amendment, for example, says, nor shall any state deprive you of equal protection or due process of law. So the constitutional text anticipates that we'll have some boundary line between governmental conduct and non-governmental conduct. Where precisely we draw that line has great implications, too, for maintaining a sphere of individual autonomy and choice. If everything we do as individuals or businesses or what have you is regarded as somehow sanctioned or not restrained by the government and therefore subject to constitutional limitations, the sphere of individual choice, the sphere of individual autonomy, would be greatly constricted. And while we might not like the idea of people deciding with whom they will deal, let's say on the basis of race or gender, in a private sphere, that should be a choice left to them. And if we constitutionalize their behavior under a broad-based state action doctrine, it would seriously curtail individual choice. Moreover, in the state action area, the court is very mindful of the legitimacy of its role in our democratic scheme. Every time the court expansively defines state action, it's potentially opening the door for constitutional adjudication. It's opening the door for the court to intervene and monitor decisions made elsewhere, which implicates matters of federalism and matters of autonomy, individual autonomy. In other words, if we have a broad state action doctrine, we're potentially making federal constitutional cases out of a whole variety of action.